Hello, I hope you guys are having nice time staying back home, staying safe. Today we are here to discuss about our topic legal psychology and trend of compliance and enforcement of law in Nepal. This is the chapter 9 of our syllabus and we will be proceeding ahead with. So first of all, defining the psychology. Psychology is the study of mind and behavior. It is a study of mind. It studies how it works and how it affects the behavior. So the connection between mind and the behavior is the subject of the psychology. APA, American Psychology Association, asks that it embraces all aspects of human experience from the functions of the brain to the action of the nations, from child development to the care for the aged. So it says about the theories which says that how the people develop. As Sigmund Freud had already stated that a child and his or her behavior, growing nature will be determining the his or her future as well. So as per his psychoanalytic theory, he said that if a child has grown up with certain deficiency in his growing up period, then that will be shown in his or her adulthood. So there are different types of psychology that serve different purposes. There is not fixed way to classify them, but still there are some common types. Just like psychology can be divided to be a cognitive psychology, in the same way clinical psychology, developmental psychology, forensic psychology, evolutionary psychology, legal psychology, neuropsychology, and health psychology. These are only the certain types of the categories which we can find, but still there are lots more divisions which can be found. Just like there can also be organizational psychology as well. But moving forward, now let's deal with a legal psychology, the major concern of our issue. Legal psychology is a modern term that refers to the study and use of psychology as it applies to the legal system and the people who come in contact with the legal system. Remember, the psychology which is in contact with the legal system. In another term or in another way, we can say that any kind of the things which is in relation with the law and which is in relationship with the psychology as well, that will be amounting to be the legal psychology. People who work in the area of the legal psychology work with methods of understanding, evaluating, questioning suspects, evaluating jury candidates, investigating crimes and the crime scene, forensic evidence investigations and other legally related situations. Here, methods of the understanding, evaluating and questioning the suspects, how the suspect is to be questioned, how not only the suspect, also the victims as well, and also the witness as well, how they will be questioning and how much we are to rely on them is all the matter of the legal psychology. So the term legal psychology is used to differentiate this field of the applied psychology from the more theoretical based clinical psychology. Before moving forward, let me discuss something about the clinical psychology. Clinical psychology can be said as psychology which will be used in a hospital or the psychological services used in a hospital. Just like we said that if you are mentally retarded, then you are supposed to get the medical services, right? That is said to be the clinical psychology. This will be practiced in the hospital by the psychiatrist. It is purely a medical term and medical issues. A person, when he or she will be in problem of the psychological problem or mental issues or mental health, then that person will be moving to the hospitals for the further processing or for making themselves cure from that very disease. Then it will be regarded to be of the clinical psychology. But here, legal psychology is not confined with this theoretical aspect. It is more about the legal aspect. It says about practices in the court. It says about the treating with the people who are there as a victim or can be as a suspect as well. So now, law and legal psychology. There in the slide, you can see the two pictures. In a right corner of your side, there is a symbol of the law, whereas in another side, in the left corner, this is of the psychology. It is a symbol which symbolizes the psychology. So now, here moving forward, as Clifford in 1995 indicated on the surface, indicated that on the surface it could be seen as if law and psychology share common concern in that they are both trying to understand and predict the human behavior. Here, both psychology and law tries to identify or try to guide the human behavior, as law said that something is to be done which is not prohibited by law, whereas that behavior is guided by the psychology of the person. However, beyond this commonality of the focus, law and psychology can be seen to diverge at the level of its value, basic premise, their models, their approaches, their criteria of explanation, and their methods. Tapp in 1969 has gone as far as to argue that while law is value-laden and subjective, relying upon traditional and precedent, as we have already discussed that precedent is a source of law. And Tapp said that laws rely upon the tradition and the precedent. Tradition means customs or customary values. This is also one of the source for the law, whereas psychology is value-free and objective. It relies on the empirical ratios. If we see the theories of the psychology, then all the theories which has been propounded by the theorists of the psychology, they have done an empirical study and made it. Just like Sigmund Freud, just like Carl Roger, all of them had done the empirical study and theorized the theories of the psychology. Further, while law is a practical art, a system of rules, a means of social control concerned with solving practical problems, psychology is a science concerned with description, explanation, understanding, prediction, and control of the human behavior. So here, it tried to say that law is there to control the people. Law is used as a controlling mechanism, whereas psychology is also a social science which is concerned with explanations and also the prediction of the human behavior. It answers why the person behaved like that. Whereas law says what is right and what is wrong. Whereas psychologists say about why the person has committed the very act. Is there anything behind it which is trying to connect with it or not? Carson and Bull in 1995 said that it is no longer a question of whether psychology has a contribution to make to the law and its practices. Psychology is making a significant contribution in a number of other ways. There is no question. Either there is connection between law and psychology is no more a question, because there is obviously a relationship between these two streams. Because numbers of the psychologists are being appointed for the purpose of solving legal issues and legal questions as well. They go on over that. The important question now concerns how the relationship will flourish. Yes, how the relationship will flourish. They do have a very concern with each other. Law and psychology are interrelated with each other. There is obvious, and the obvious answer is yes. The only region or the only question to be answered is how much they will come together and go together to solve the problem. Well, let me share you one story before entering into the trends and compliance of those legal psychologies in the legal trends. Okay, in the midnight, or can be at the time of 11 a.m. or 12 a.m., 11 p.m. or 12 a.m. or 1 a.m. as well. So here a person saw that a person snatched a bag from another person and killed him. He rushed back to the car. The person who saw it was in 10-meter distance from the perpetrator and 20-meter distance from the victim. The case was filed in the court. And investigation was started. The person who saw the incident or who was at the scene of the crime was taken as an eyewitness. Then, when he was there for the statements as a witness, he was there to identify the perpetrator, as he was an eyewitness of the incident. In the same way, he will be made to identify among those people who were standing over there. So there will be few of the people standing who are similar in nature, who has a similar height, similar complexion, and among those 4 people he will be made to choose one, and his statement will be taken as evidence to convict the perpetrator. Remember, his statement will be taken as evidence to convict the perpetrator because he is the eyewitness. He saw the incident. He saw the victim. He saw the person running to the car and going away. Now, here the question is that if the person whom he pointed is the perpetrator or not. Can we say that the person who has been pointed by the eyewitness is a real perpetrator? Then, whether the eyewitness really identified the perpetrator when he was running to the car. Yes, he was an eyewitness. He had seen the person, but never before. It was the first time when he saw both of the people, the victim as well as the perpetrator. Here now, question is whether the eyewitness really identified the perpetrator when he was running to the car. Now, another question is either he actually remembered the one whom he saw at the time of the incident. Actually, if he had seen the person, then he had really remembered the person or not. Does he really remember the face? Does he really remember it, or he was panicked? In general context, we can say that if a person saw a crime, then what will be the psychological state of that very eyewitness? Yes, this is a question. So if we remember the movie 12 Angry Men, then there was eyewitness as well. But whether the eyewitness was reliable evidence at the time or not, the distance, the eye power, in the same way, the running train, all of those things were to be considered. So, in that very movie as well, the eyewitness was not taken to be the reliable evidence. There were numerous of the other conditions which did not confirm the identification made by the eyewitness in the very movie. In the same way, in the very situation as well as in the story which I mentioned earlier, in that as well, the eyewitness has seen the person for the very first time, and he was in the distance of the 10 meter. He was running to the car and run away, staying in the car. Here now the question is, can we rely on the eyewitness or not? Now let me say one more thing, that in the time of the interrogation, well, if there is a perpetrator who has been identified by the victim, by the witness, and for example, let the person be okay. For example, let's take that the person who has been identified as a perpetrator by the eyewitness is a real perpetrator. In that time, there will be the interrogation by the police as well. So here the question is, will he confess or not? What is the psychological state of that very person? Here the matter is, did he regret for the incident or not? Or he is an occasional criminal or habitual criminal or occupational criminal? That is a matter of the question. So now, when he or she is being interrogated by the police, was there the audio or video recorded or not? So research has been found that during the police interview, very few suspects changed from the initially denying their guilt to later admitting it. Admission, or we can say the confession. Just like a person is denying for the in the very beginning and accepting at the very later is not, it was not found. In fact, the vast majority of the suspect who confessed did so at the very near to the beginning of the interview. A research of the England shows it. It said that the person who has denied from the very beginning very rarely changed their statement and accepted or admitted in the latter stage. Or else, most of the people or most of the perpetrator who has accepted or accused, let's say accused, most of the accused who has accepted or confessed, they confess in the very beginning, or we can say that at the initial point of the interrogation. So here, the research of the England says that it is better to record the very statements so that one can identify the psychological state of the accused at the very moment. Now let me give you another example of another story. I hope most of you have studied or heard the story of the Paribandha by Guru Prasad Mailani. In that very story, a person was found dead, and an innocent person went over there to give some water. Let me explain it in Nepali. कोही मान्छे जुन परिबन्धमा परेको छ त्यो मान्छेको घरमा बास बस्न जान्छ, लाहुरे हुन्छ। लाहुरेलाई कसैले खुकुरीले काटेर भागेको हुन्छ। त्यो चिच्चाएको आवाज सुनेर त्यो घरको मान्छे र उनको श्रीमती उनलाई हेर्न जाँदाखेरि छटपटाइरहेको अवस्थामा देखेको हुन्छ र उले के गरेको हुन्छ त पानी खुवाएको हुन्छ। पानी खुवाउँदाखेरि श्रीमतीले राम राम भनेको हुन्छ। त्यति मात्र नभइकन त्यो इन्सिडेन्ट हुनुभन्दा एकछिन अगाडिको इन्सिडेन्ट के हुन्छ, श्रीमान र श्रीमती बसिरहेको बेला श्रीमानले किरा आएर किरालाई मार्न खोज्छ। श्रीमतीले के भन्छ, नमार नमार भनेको हुन्छ। त्यही नमार नमार भनेको र मारिसकेपछि वैकुण्ठ बास होस् भनेर जुन स्टेटमेन्ट श्रीमतीले भनेकी हुन्छन् त्यो स्टेटमेन्ट बाटोमा आएको एउटा बटुवाले सुनेको हुन्छ। रिमेम्बर, सुनेको हुन्छ, एयर विटनेस। अनि त्यो मान्छेले जब बास बसेको मान्छे मरेको देख्छ, थाहा पाउँछ र पानी खुवाउन जान्छ, भोलिपल्ट उसैलाई दोषी करार गरेको हुन्छ। ऊ त्यो घटनाबाट आफू डराएर भागेको हुन्छ। ऊ आफूले घटाएको होइन त्यो घटना, उसले मारेको पनि होइन, तर त्यति हुँदाहुँदै पनि ऊ भाग्यो। उसले त्यो घटना सिधै गएर भन्न गएन, यावत कुराहरूलाई आधार मानेर numbers of the circumstantial evidences, like he ran away from the scene of crime. He did not come to complain for the very first moment. There was something, and along with that, air witness was the major witness taken. Just like Ram Ram bhaneko suneko थियो. Not only that much, श्रीमतीले वैकुण्ठ बास होस् भनेको सुनेको थियो, नमार नमार भनेको सुनेको थियो. This is all about the evidences which were presented and the person was punished. This is the paribandha. So here the question is it rational to be based on the air witness? कसैको आवाजलाई हामी कतिन्जेल कतिसम्म याद गर्न सक्छौं? Can we identify the voice of some other people whose voice has been just heard for the first time? Not only same thing, the evidences, just like air witness, eyewitness, which has been regarded to be a very important evidences. How can we rely, or how much it is reliable, is the questions to be answered. So these above mentioned questions are the questions of legal psychology. Legal psychology deals with these very stuffs. Now, moving on to the compliance and enforcement of law in Nepal. So, let's have one thing, that how many people follow law, how they perceive law. You have already done study about the people's perception about the law. How much people think that it is related to them and how much it is not. It is also the part and parcel of the legal psychology. The work which you have done in your Dasai vacation and the study which you have made and your findings is outcome of the legal psychology. How often people said that it is for them? How many of the people said that it is for someone who is wealthy? You have also got it right. Garibलाई ऐन, ठुलालाई चैन. Not only that much, how people perceive it. Is that something to be followed for other, or it is for themselves? Let's take an example of lockdown. These days we are in lockdown. In lock, but really not in down situation, right? We are in lockdown. We are within the periphery of our house, and remember how many of people are outside as well. Few of the people are not following the law because it is their compulsion, as they have nothing to eat and nothing to do over here. So why they are compelled to be back to their hometown? So why they are walking on the road? It's not like they are disobeying the law. Rather, it can be said that they are compelled to disobey the law. Whereas few of the people are taking law as granted. They come inside the house when the van of the police arrive, and or else they try to be outside. They think that following law is for the government, or so now here in Nepalese legal system, how the psychology has played the role. So if we see, we have numbers of the example which shows that there is a remarkable place of psychology in our Nepalese legal system. For instance, there is a general defense where insanity, infancy, drunkenness and intoxication is regarded to be general defense. Not only that much, principles of civil law and criminal law, juvenile justice system, in the same way eyewitness and ear witness, evidentiary value of the witness, and motto of the punishment and sentencing policies are the few of the arenas in which we will be discussing. But remember that this is not limited within this only. We still can have lots of the things which is interrelated with the legal psychology. And few of the things which we are going to discuss for this session is this. Well, general defense. If we see that the person who is below the age of 18 are said to be minor. All of you know CRC, and also all of you know the Child Right Act 2075, in which it has been clearly defined that the person who has not attained the age of maturity, that means the person who has not attained the age of 18 is regarded to be minor in Nepalese legal system. So here, infancy is the very same thing. So one who is below the age of 10 is totally immune from criminal liability. The one who is below the age of 10 is totally immune from criminal liability. Whereas if the child is from 10 to 14 years, then the child will be liable for up to 6 months or 1 year at a reform home. Whereas if the child is from 14 to 16, then half of the punishment which will be given to the adult will be given to the delinquent. And if he or she is below the age of 18 and above the age of 16, then 2/3 punishment will be given to the person. Here, infancy as a general defense. Why? It means that the person who is child will not be able to develop the consequences, or will not be able to develop the mens rea to commit the crime. Another one is insanity, or we can say it as a mental illness, or in another terms we can say it as a mental retardedness. Most of us are aware about the numbers of the cases in which the people are immune from their criminal liability because of mental illness. The mental illness shows that the person is not able to determine or to foresee the consequence. He or she will not be having the knowledge that what he or she is doing and why he or she is doing that. This is a part and parcel of the psychology as well, which has been taken as a defense in the law. So mentally retarded persons are not liable for the criminal liability. One who do not have knowledge of the consequence, or the one who is not in situation to have the knowledge, will be totally immune from the criminal liability. That person is to be sent to the hospitals for the treatment, or we say that clinical psychology, right? Yes, he or she need to be treated to the hospital so that the person can be back or regain the memories or regain the psychological perspective of the very person. Next one is drunkenness and intoxication. Here, drunkenness and intoxication is not fully immune, or the person who commit the offenses in a drunk situation or in intoxicated situation will not be totally immune. But if it is administered under the misrepresentation or coercion, then that will be the ground for the defense. Intoxication can be drugs as well, not only the drinking of alcohol, and it can also be from the different substance abuse as well. So, if the person self-induced the intoxications, then there will not be any kind of the defense. Whereas if it has been administered by the pressure of some other people or misrepresentation, then the person can claim for the defense. So if the family members, within the family members, the crime has been committed, then drunkenness can be the ground for the mitigation of the punishment. Whereas drink and drive is under the strict liability, the person will be totally liable for driving while drinking. So it can be stated that drunkenness and intoxication is not fully immune or is not fully defense, but yet to some extent it can be taken to be the defense. Infancy, mental illness, and drunkenness, all of these three are regarded to be the general defense, because there is a principle of the criminal law that act alone does not amount to crime. There should be, or there is a requirement of mens rea as well. With relation to the relative liability, I hope you have studied it in a GCL as well. In relation to the relative liability, a person if commit the crime with intention and the action as well, then the very person will be liable for the punishment. But if there is no mens rea, or if there is no intention, if the person is not thinking about doing that very offense, then that will be act. Only the act will not be amounting to be the crime. So here, in the state of infancy or the minority, in the state of insanity, and in the state of drunkenness or intoxication, the one will not be in the state to segregate what is right or what is wrong. In the other word, we can say that the person will not be able to consider the consequence of the very act. So it will not be regarded to be of the criminal psychology. So here, in all of the above situation, mental state of the person is examined and they were provided with the excuses. All of these above mentioned states, the legal psychology perspective is that the mental state of the very person will be tested. Was he in the drunk situation? Was he in a mentally retarded situation or not? Will be determined before giving the punishment. Now here, juvenile justice system. Here, in the juvenile justice system, there is a provision that in the juvenile bench where the cases of the juveniles will be heard, there will be the child psychologist in the bench. In the juvenile bench, there will be 3 people. One judge, another child psychologist, and the social worker. So here, the very point to be noted is the appointment or the provision of child psychologist in the bench. The child psychologist is in the bench to identify the region of the commission of juvenile delinquency. He or she will be examining the delinquent juvenile so that it can be identified the region behind the psychological state of the very child. In the same way, juvenile reform home is another example where psychological perspective is being used. Juvenile reform homes are for the purpose of reforming the children. Detention has always been the last resort of the punishment, until and unless there are another mechanisms to be provided, just like admonish them in the same way to send them for suspended sentence. After all, their stay, or we can say that their time duration in the reform home can be the last resort. And the juvenile reform home is also there for reforming our children. There is also the appointment of child psychologists in the reform home so that the state or mental state of the child can be reformed. So here is another connection, law and in relation with the psychology. Further, there is a principles of the criminal justice and legal system which vividly shows the connection between law and psychology. It says that legal psychology. In the principles of criminal justice system, there are few of the examples which I am going to give are: act alone does not amount to crime. It needs mens rea or intention as well. Ignorance of law is of no excuse. One cannot say that I did not know the law. One is supposed to learn about the law as soon as law is published or is enacted. In the same way, information given in the good faith is not amounting to crime. For this, let me give you an example. For example, Um, for example, a student came to a teacher to say that your someone beloved has been dead. Someone who is very beloved of you has been killed by someone. That is the information which has been given by a student in a very good faith to a teacher. But unfortunately, the teacher was a heart patient. So he died or she died immediately. Here, the student is not liable because the student have given the information in a very good faith, just merely to give the information. So here, the child will not be liable. So here it shows that the information has been given in a good faith. It is all about the psychology, right? Then now, another one is principles of civil law. So here, few of the examples are like good neighborhood would be maintained. It is a principle, right? In the same way, act against the interest of the public will be invalid. If any civil laws are to be made, then those laws are to be made as per the intimacy, or it's as per the intention or as per the willingness of the people. Guti Bill is a vivid example for it. Guti Bill was proposed, but it was not passed or it was not enacted, because now most of the people came into the floor protesting against it because it was against the interest of the people. Another one is act against the public interest is not to be carried out. So once again, if any act is to be taken, or any act is being taken which is against the public interest, then it will not be accepted. Just like in democratic changes as well, we can see there was a monarch system. Later on, it was not accepted by the people, and now we do have a republic democracy. It's all about the wishes of the people, right? It's all about the psychological state of the people. But yet, we also find that few of the people want king back. Remember when you were doing the study? Few of your friends also said that Raja nai hunu parcha deshma. This is the psychology of the people. This is the mental state of the people, right? So there are the few principles, or we can say that principles which are in a relation with the psychological part of the legal mechanism as well. So why people follow law? It is because of the psychology. Well, then motto of the punishment. Why punishment is given? Punishment is given to deter from committing further crime. If you remember the principles of the punishment, then deterrence, preventive, in the same way reformative, right? All of these punishment theories also try to say is about the mental state of the perpetrator, and not only the perpetrator but also the people around as well. So our sentencing act says that to deter people from committing further crime, and also to deter the perpetrator who has already committed the crime, right? And also make offender or perpetrator regret on the act which has been committed by them. Feel regret that he or she had committed the crime. In the same way, while giving the punishment to the minor, the best interest of the child will be always considered. Not only that much, either they feel regret for the act which they have committed or not. In the same way, either they do have a wish to live a good life in the future or not. All of these things will be considered before giving the punishment. So generally, juveniles are not given harsh punishment. It is, to some extent, we can say that it is lenient punishment. As we have already discussed that a child, if commit any kind of delinquent act when he or she is below the age of 10, then he or she will be totally immune from that liability. So this is the motto of the punishment. Well, the evidentiary value of witness, eyewitness and ear witness. We have already discussed these very witnesses before as well. Eyewitness in the case of the 12 Angry Men, and the example story where he saw a perpetrator and the victim in the distance of the 10 meters and 20 meters. In the same way, in case of the ear witness, we also discussed it in the story of the Paribanda, how the eyewitness and ear witness is not always reliable. But it doesn't mean that it is not reliable totally. If the person has seen it from the very closely, or it is very used to person to him or her, then he or she can easily identify. But if it is if it is in such a situation that it is occasional, or you have seen the very person for the very first time, then in those situations these eyewitness and even ear witness may not be reliable evidence. For example, how many of you remember what is the color, or what is the color of the bird just fly from your eyesight? Or it can be like who just come across you when you are listening to this lecture. Might be like if this is your mom, or if this is your dad, or if this is your brother and sister who is always used to with you, then you can identify him or her, right? But if it is a very unknown person just come across you and go away, then it may be difficult to identify it. So this question is raised by the legal psychology. So Evidence Act, in the context of Nepal, Evidence Act says that the eyewitness is one of the best evidence for the purpose of the evidentiary value. It can be stated that the person who had done that act, or who had directly seen or known the act, incident, or the condition or the situation, then that person will be regarded to be the eyewitness. Remember, who had directly seen or known the act. As in the example, the person who saw the scene of crime. This is the eyewitness. The oral evidence has to be direct in nature, to mean if the evidence has to be produced to the fact which could have been seen, heard, or felt with the help of any sense, that evidence has to be produced by the person who has directly seen, heard, or felt as an oral evidence. It is said that if the evidence is given by a person who has heard it from another one, then that will not be regarded to be the evidence. It is always said the evidence should be direct. Direct evidence is regarded to be the best evidence. But here the only question from the legal psychology perspective is that how much the person will remember it. Just a very short example. How often we remember all those things which we have gone through in our classes. Sometimes we even do not remember who was there in our class as well. We even do not remember that. We even do not remember who came across us when we were in the class. Right. In this situation, how much it is reliable is the question which has been raised by the forensic, or in the same way we can say that legal psychology. Right. So yeah. Well, then we have some theoretical perspective as well, which shows the application of the psychological perspective or legal psychology. The first one is of the Oliver Holmes. Oliver Holmes is a theorist, or we can say that a scholar of the realistic school of thought. And he had propounded the theory which we often see it as a bad man theory. The person who commits the offense is regarded to be the bad man as per Oliver Holmes. He said that when the person is arrested or in a verge of getting punishment, at the time he will be thinking about what will be the amount of punishment given by the judge to him, rather than he will not be thinking about in which provision or in which act there is what provision. Right? He will be concerning about what is the punishment or what is the amount of the punishment to be given to him. So here, his thinking is not in the legal provision. Rather, his thinking is on how much the judge will give. He will be thinking about it, right? This is a psychological perspective, which Oliver Holmes tried to explain. And in the very same theory, Oliver Holmes also tried to say that judgment of the case will be influenced by the psychological perspective of the judge. Psychology of the judge. What is the thinking of the judge? May he mitigate the punishment, or he will aggravate the punishment, or what? It can be the question of the judge. Just like in the earlier example, when the person snatched a bag and killed the person and ran away, in that situation, will he consider why he snatched the bag? Might be he was snatching the bag because that bag belongs to himself, and he killed the person because the victim who has been killed was actually a robber, right? He committed the robbery. Might be the situation, but here the fact of the crime says that the one who ran to the car killed the one who died. So this is the scenario, and the scenario can be interpreted by the judge as per his psychology. He may strictly, or in the same way we can say that if he is a formalistic innocent, he will be seeing that he snatched the bag and he killed him, so he will be liable for the life imprisonment. Or else he may also think that the scene of crime has been committed because the one who is victim now was the perpetrator, because he was the one who committed the robbery and he was the one who tried to run away with the bag. So this is the situation. So here, as per Oliver Holmes said, that the judgment of case will be influenced by the psychology of the judge as well. Now, another one theory which is related with the legal psychology is the Savigny's theory of common consciousness. We also see it as a vague gist, right? Laws are to be made as per the common consciousness of the people. We have already discussed this very thing. It means that laws are to be made as per the psychological acceptance of the general public. If any kind of laws are to be made, then that laws are to be accepted by the people in general. Yeah, accepted by people. So this acceptance is the psychological aspect. So here, along with this, all of the examples and these two theoretical perspective, you can add more as well. It shows that how legal psychology is interrelated, or we can say that tangled with each other. Law and psychology are interlinked with each other in each and every perspective. But here, the matter of concern is that legal psychology is concerned with the empirical study. It says that legal psychologists always are there with a resource, empirical study, as we have already mentioned, right? In the same way, they will also be helping in the cases as expert witness. Furthermore, they can play a role in the legislation making and as also a guidance. Also will have a advisory role, and they can also have a amicus brief, right? They can play a role as an amicus brief. So legal psychologist can be one of the very attractive profession for the person who is studying law. And here it shows the train of accomplishment as well. This is how often people are following law, how it is being used, and how our laws are implementing the psychological perspective as well. So there are a few questions which are to be answered, just as how often we are supposed to depend on eyewitness and air witness, or it is better to be based on the physical evidences, or there can be a very different psychological perspective from which we can see that law will be stronger if the psychological perspective is also considered. Okay, so this much for today. See you in our next session. Thank you so much. I hope you got some ideas about the legal psychological perspective. Stay safe and stay happy. Thank you so much.